Welcome to the Legally Speaking podcast. I'm your host, Rob Hanna. This week, I'm absolutely delighted to be joined by Brian Mack. Brian is a partner at Quinn Emanuel. He has expertise in commercial litigation and IP disputes. Prior to joining Quinn, Brian was an associate and patent agent at Ropes & Gray. Brian completed his degree in Bachelor's of Science at Hamilton College and Master's of Science in Electrical Engineering at Columbia University. Prior to joining Quinn, Brian worked at Kencast and General Dynamics Advanced Information Systems as a software engineer. Brian combines his knowledge and training to intellectual property matters involving computer systems, architecture, data encryption, and telecommunications. So a very big warm welcome, Brian.
Hi, Rob. Great to be here.
Oh, it's great to have you on the show and fascinating background. Really keen to get into today's discussion. And before we do that, we do have a customary icebreaker question here on the Legally Speaking podcast, which is, on the scale of 1 to 10, 10 being very real, what would you rate the hit TV series Suits in terms of its reality of the law if you've seen it?
So I have seen it. I just recently started watching Suits as it was re-released on Netflix last year here in the States. But on a scale of 1 to 10 for reality of the law, I'd probably give it a 4. I mean, obviously it's overly dramatized, made for TV, and the courtroom scenes and all the drama just don't really resemble the reality that I see in the courtroom. But there are some, realistic parts. I think it does a really nice job of showing the late nights and the painstaking review of piles and boxes of documents associated with the legal profession. So it does a good job of capturing that drudgery, if you will, that can be associated with the practice of law. I also really like the relationship between Harvey Specter and Mike Ross. I think a lot of people assume lawyers only interact with and rely on other lawyers, and that just couldn't be further from the truth. I mean, we constantly rely on people without formal legal training, like technical experts and jury consultants, and even our great support staff here at the firm. So we strive to surround ourselves with the smartest people in the room, and I think that's similar to Harvey when he is associating with Mike Ross. So in that small sense, it rings true, but otherwise, I think a 4 is probably the right mark.
Yeah, and I think that's a very well stated answer. And with that, we should move swiftly on. So I obviously touched on very, very briefly in the introduction, but Brian, I'd love for you to tell our listeners a little bit more about your background and career journey today.
Sure. So, I mean, even at a very young age, I was always fascinated with electronics and computers. And I think that naturally just led me focusing my studies on math and science throughout high school and college. So I received undergraduate and graduate degrees in computer science, physics, and electrical engineering. And that was before I started my first full-time job as a network software engineer for a small startup company in the New York City area. I stayed there for a few years until one day I kind of looked up and looked around and saw all the other software engineers just glued to their computer monitors. And there was virtually no personal interaction or interpersonal skills required with that job. And I quickly realized that I just wasn't really, cut up to be a programmer for the rest of my life. So I needed to transition into something that was a little bit more fast-paced and exciting and with more human interaction. But I also didn't want to give up my technical background, my computer science, physics, and engineering background. So I started looking into law, and specifically intellectual property law. And I also had a little help because I have an identical twin brother who also has an engineering background, and he already started looking into the legal field and was studying for the LSAT. So I kind of followed in my twin brother's footsteps in a sense. I left the computer programming job and I joined, at the time, it was an IP boutique firm known as Fish and Neve, and then they merged with Ropes & Gray. And I was working as a technology specialist at the Fish and Neve IP group of Ropes & Gray. And they have a patent agent program where you attend law school at night while working full-time during the day as a patent agent. So I began my career more on the IP corporate side of things. And then when I finished up law school in New York City, I knew I wanted to transfer out of the IP corporate practice group and go 100% into litigation. And that's when I moved over to Quinn Emanuel in around 2011. So it's been about 13 years now. And I've been here ever since.
Yeah, and I mean, it's an incredible journey. And, you touched on it there, you coming from that sort of non-traditional background to then the legal world and now partner, so can you walk us through how you've become an intellectual, litigation partner at one of the world's, arguably best and largest disputes firms in the world?
Yeah, I mean it's a lot of hard work, a lot of late nights. When I moved over to Quinn Emanuel in 2011, they were active. They had just started the Apple Samsung smartphone wars, and that case was really would be all encompassing for the next 7 years of my legal career. It was two jury trials in San Jose, two evidentiary hearings in front of the International Trade Commission in Washington D.C. And Quinn Emanuel has a policy of it's a really they staff their cases very leanly, so a lot of the substantive high quality work product gets pushed down to the associates and even the junior associates. So I hit the ground running when I moved over here, and I had that strong technical patent background from my experience at Ropes and Gray, and put in the time. 7, 8, 9 years later, I'm now IP litigation partner, and I specialize in patent, trademark, trade secret, copyright cases, as well as a host of other matters. One unique thing about Quinn Emanuel is that they really try to have each litigator be just a general purpose attorney who can pick up any complex commercial case and just hit the ground running. A lot of people do specialize, and I have a technical background, so I ended up specializing in intellectual property law. But I also work on lots of other types of cases as well.
Yeah, and I guess it's refreshing, isn't it, to get that variety. I mean, one thing this show is all about is legal careers and inspiration. And, there might be people listening into this that might be similar to you in the sense I'm in a profession that isn't really fulfilling me. You wanted to get that more human interaction. You wanted to have something slightly different, but not lose that background. So in terms of maybe helping people with transferable skills or moving into a different industry, how did your technical training help you transition to a lawyer? And then particularly then to sort of make that move to Quinn Emanuel?
Yeah, that's a great question. So, I mean, I have to explain complex technology to the judge and the jury on a daily basis. So my technical background obviously was immensely beneficial for that purpose. And one of the keys to really appealing to the jury is simplifying these complex technologies and in terms that the jury can understand. So we use a lot of simple analogies that kind of demystify the complex technology, and those are really key, at the jury, in front of the jury. And we kind of have a rule of thumb that the jury really only takes back the 4 or 5 most key points that it'll remember into the deliberation room. So my main goal, and the main goal of every lead trial attorney in these complex IP cases, is really to connect with the jury and make them understand your position better than your adversary's position. So you really want the jury to remember more of your 4 or 5 key points as opposed to your adversaries when they go back into the deliberation room. And it's not really an easy thing to do, but we've kind of mastered an approach at the firm that's quite effective. But it doesn't really mean that you need a technical background to work on the types of cases I work on. You really only need a couple technically trained attorneys on each trial team in order to succeed. And those 1 to 2 attorneys become invaluable members of the team and kind of act as a conduit for all the technical analysis that funnels through them. So that was really important when I was making my decision on moving to Quinn Emanuel. I really wanted to, I didn't want to just throw away all the late nights and the complicated engineering classes and physics and computer science work that I had done in my past. I still have my textbooks in the library here, and I do pull out the books occasionally from time to time. So that was really important to me to kind of integrate my technical background and my technical training into my new career path. And I found an exact fit with intellectual property law.
Yeah, and I guess what's fascinating about your particular area of law as well is whilst, certain trials and cases might be similar, like the details matter. So there is no sort of one size fits all. As I always say, you've got to be specific is terrific in terms of really getting those details across. You've touched on it there, but maybe, I don't know, do you have any sort of rituals you go through in your head before sort of going into the court or facing the jury, and some of the challenges that you've sort of been through? Are there any that have stood out to you over the years?
Yeah, I mean, There are a lot of challenges with this type of work. The principal challenges are really come down to just the technology and dumbing it down in a way that you don't really lose focus and the jury really understands your side of the case. There's another challenge though. If you dumb it down too much, then there's a notion in patent law that if your invention would have been obvious to someone of ordinary skill in the art, you're not even entitled to the patent in the first place. So if you're on an IP case that's a patent case and you end up oversimplifying it to the jury, that's not really a smart idea either, because that really risks the jury finding that your inventions aren't really special enough that they should be worthy of patent protection. So I think the most challenging thing really is just to strike that delicate balance with the jury. You really have to get across that you came up with a great idea, and this is worthy of IP protection. But you also really have to simplify it enough so they really understand what you're talking about and what your experts are talking about. Otherwise, it's just like drinking from a fire hose, and everything goes over their head. So that's definitely not something that you want to do. So I think that's there's not really a ritual. Every case is different. Every case is brings its own complexities with it, and I really just take each case as it comes.
Yeah, and it's a great mindset as well. And you made a very interesting point that it didn't come to me, but it's an obvious one. Like when you say it, you can't make it overly simplified, because then what have you gone away and, we talk about reinventing the wheel and these amazing creations. There needs to be something that is valuable enough that you need to protect that not everyone is thinking about, hence the value. So they really like that point.
Exactly.
Okay. Let's talk about some of your cases. You talked about the first 7 years, Samsung, Apple, but that's just one. You've worked some huge cases in the technology sector, Google, Yahoo, et cetera, et cetera. So what are your most interesting, or what is the most challenging case to date that stands in your mind?
Yeah, so when I say I focus on IP cases, that's really an oversimplification. So like I mentioned before, Quinn Emanuel does really strive to make its lawyers like generalists. So everyone should just be able to pick up any type of case and any type of litigation anyway and run with it. And there's these commonalities across all forms of litigation, and the firm does a great job nurturing those types of skills. So it's not really uncommon for me to work on, IP cases one week, and then data privacy cases, breach of contract, antitrust, even product liability cases. With my technical background, though, I just personally enjoy, the more technically complex cases. At Apple, Samsung, it wasn't that case wasn't really challenging because of the technology necessarily, but it was more challenging just because of all the different venues and jurisdictions that were at play. Like I mentioned, there were two jury trials. There were also two different International Trade Commission hearings pending in Washington, D.C., and there were countless foreign cases. There were actions filed in the UK, Japan, Germany, Korea, Australia, and I'm probably missing a handful of others. Apple spread its legal representation around to multiple firms, but Samsung largely trusted Quinn Emanuel to handle everything. So it was truly a transformative matter for me personally and for the firm. So I think the Apple Samsung smartphone wars was definitely the longest matter I was on. It was about 7 years. But there have been many others. We just finished there was a trade secret dispute between two electric vertical takeoff and landing air taxi companies here in Silicon Valley. So you basically think of, deboarding your plane at the airport. Instead of going to the Uber line, you go to the air taxi line, and you have this yellow helicopter type contraption that's all electric. Takes off vertically and then transitions into forward flight like a plane, and then can land anywhere in downtown New York, downtown San Francisco, wherever you're heading. So that we're always on the cutting edge, and that's what keeps me here, is that we have extremely interesting clients and interesting cases, interesting technology. I feel like I become like the technical subject matter expert on every case because I'm just so deeply immersed in the technology. After, when you people don't realize that when you file a case, it could take multiple years before it actually makes it to the jury. So during that time, you really learn the ins and outs of every different case that you're working on. And every case, brings its own unique challenges in that regard.
Yeah, and like you say, that's probably what keeps it super interesting for you. And I love that example you give. Someone as a sort of tech enthusiast like myself, the air taxi, it reminds me of when we had Piers Linney, who's Dragon's Den, the equivalent of Shark Tank over here, who was a former lawyer, come on the show. And he talked about, well, think about it, Rob. I've got a young daughter, under 3 years old. Your daughter's not going to trust you to drive a car. That will be normal. Automated cars are going to be normal in the next, 20 years. It's going to be a new normal behavior. You look at Wuhan now, they've already got automated taxis. You put in a pin to the car and then you're away and go. And so, I'm super excited about cutting edge technology and things that are going on and the next thing. But like you say, brings those sort of arguments or people judgments, particularly when it's trade secrets, because all of that is super important. So let's stick on trends. We're going to talk about AI in a bit because I can't not do a podcast and talk about AI nowadays. But what are some of the what are some of the things that you've been noticing in terms of trends and the types of cases you've been working on? Obviously, there's a wide variety, but is there any sort of reoccurring trends?
Yeah, that's another good question. Since I've been at Quinn Emanuel for over a decade now, I have seen a lot of trends, especially on my IP cases. It used to be the case when I first started at the firm that we would see a lot of just straight patent infringement case claims with nothing else. Today, we don't really see straight patent cases all that often. We see more hybrid cases with, patent, trade secret, and then other claims like unfair competition or even antitrust claims. There's the California Unfair Competition Law, which is in the Business and Professions Code. It's extremely broad. It generally prohibits any unlawful, unfair, or fraudulent conduct in connection with business. And courts have interpreted those terms rather broadly. So these unfair competition law claims can be a really powerful tool that are used in parallel with some of these IP claims, like the traditional patent claims. So today, I think there's a general trend that we're seeing more of these hybrid type cases with traditional IP claims mixed in with other types of claims. We've also seen there's been a dramatic uptick, I would say, in the number of trade secret cases that we've been seeing. And I think that's due in part to the passage of the DTSA, which was the Defend Trade Secret Act. And that gave companies a private civil right of action in federal court. And it kind of harmonized all of the various state laws surrounding trade secret protection. So that act also includes a very expansive definition for what qualifies as a trade secret. So we've been seeing a lot of our clients using this new DTSA very effectively to combat, for example, departing employees that might leave one company with documents containing trade secrets and then use those documents at their new employer. And unfortunately, it's a really common fact pattern, especially here in Silicon Valley, where you have mobility of workers and engineers in particular leaving one company to go work down the street at the next competitor. So we've seen quite an uptick in trade secret cases as well. So I think those are two trends that I've seen over the past few years.
Yeah, no, and with me putting my sort of legal recruitment hat on there, in terms of what deems like a bad leaver, I think there's some pretty bad examples there that you say in terms of people, not leaving on good terms and all of that good stuff. Okay, you are undoubtedly a partner in one of the world's leading litigation firms. You've talked about the variety of work that you've been able to get your hands on and been able to build out yourself, but just talk us through a typical day. Give people a bit of a day in your life. What are some of the responsibilities you have as a partner in such a prestigious law firm?
I mean, the most important responsibilities are obviously to my clients. So I try to spend the bulk of my day just moving forward all the cases that I'm on. Obviously, as a partner at a big law firm, I also have business development responsibilities as well. So I do try to reserve 10% of my day. It's usually pushed towards the end of the week on business development efforts and networking efforts. It really depends on how active my docket is at any point in time. If I'm a little bit slower, I sometimes spend more time on business development and networking. Usually that's not the case. I'm usually very busy on my cases, so that tends to get kind of pushed towards the end of the week. But at any given day, I try to divide my work between the matters that I'm on, so I'm not just focused on one matter for the entirety of the day. I feel like I'm not efficient if I just work, 8 hours straight on one matter. I don't think that really benefits me or the client. So I try to do a couple hours on each matter each day, make sure everything's moving along. The good thing about Quinn Emanuel is that we have a great, highly capable associate ranks. So I really surround myself with people that I can trust, and I delegate a lot of responsibility and push that high quality substantive work down to the associate ranks. So I'm at this stage in my career, it's more the high level strategic thinking rather than the day-to-day drudgery, like I mentioned at the beginning. The other good thing at this firm is that, there isn't really all that much drudgery because we do have such high quality substantive work, enough to go around, and we have a lean staffing model. So even first year associates are taking depositions, at Quinn Emanuel, and we kind of outsource a lot of the really monotonous work, like the document review. We kind of outsource to contract attorneys. So yeah, that would be a typical day. It's a mix of just moving my cases forward each day, and networking and business development, which is equally important in this profession.
Yeah, no, and absolutely. I mean, we've had the privilege over here of, recruiting for Quinn Emanuel, and you're right, the quality of the associates and the quality of the work that the firm has is undoubtedly, top quality. And I love that sort of, what I call elevate and delegate. The smart leadership is find the right people that can really kind of be your superstars, empower them and give them the tools to be successful. Hey, listeners, we'll get back to the episode in just a moment. But first, we have an exciting update from our sponsor, Cilo. Are you a solo practitioner or running a small law firm? Then you know how challenging it can be to stay on top of the latest trends and manage your practice effectively. That's where Clio's 2024 Solo and Small Firm Legal Trends Report comes in. This comprehensive report is packed with valuable insights into the current legal market, client expectation, and the newest technology shaping the future of legal practice. Whether you're looking to boost your firm's efficiency, improve client satisfaction, or grow your practice, this report has the data-driven strategies you need. And the best part, it's absolutely free. Don't miss out on this essential resource. Head over to Clio's website and download your copy of the 2024 Solo and Small Firm Legal Trends Report. Visit clio.com/UK/LTR to get your copy today. Stay ahead of the curve with Cilo, the leader in legal practice management software. Now back to the show. Okay, I mentioned before in jest AI. Of course, we do have to talk about that, Brian, given your sort of involvement, and just keen to get your general thoughts because everyone has a view on it. But firstly, you're involved in the artificial intelligence practice at Quinn. What unique challenges do companies developing or using AI face?
That's another great question, Rob. Yeah, and I am part of we do have a practice group that's devoted entirely to artificial intelligence, and I'm a part of that practice group. So we see a lot of unique legal challenges facing companies that develop or use AI. I mean, I think it's important to distinguish. I mean, the buzzword is generative AI, but I think a lot of people forget that AI has been around for a very long time. So generative AI really is just AI that's used to output or generate text or computer code or images or even video. We've been working with analytical AI for years. Like even, when Netflix presents you a list of show recommendations or movie recommendations that you might be interested in, that might even use a form of analytical AI. So we've been dealing with AI and working for AI companies for a long time. The new form of AI that everyone's talking about, the buzzword today, the generative AI and the large language models and ChatGPT and things like that, they present many unique legal challenges. The first that a lot of our clients ask us is, how do we even protect these AI tools, these large language models? And both the patent office and the copyright office really require some form of human involvement to be named as an inventor or an author. So it really depends on whether and to what extent a human has used AI as a tool to create the invention or to create the work of authorship. That's really going to, determine whether or not you're able to patent or copyright the AI tool or the outputs of the AI. Another important issue is that we talked about patent protection a little bit before, and how it had to be non-obvious in order to qualify for a patent. There's another requirement under U.S. law is that there's under Section 101 of the Patent Act that you also have to, your invention has to be directed to patentable subject matter. And there's a lot of exclusions. You can't really patent abstract ideas, mathematical algorithms, laws of nature, and a whole host of other things. So we also have a lot of our clients asking about patent protection specifically for AI systems and AI tools. And it's a difficult challenge because you really need to frame the AI invention as like a concrete and unconventional application of an abstract idea rather than an abstract idea itself. And that's tricky to do because, AI sometimes is really about the underlying algorithms, right? It's the machine learning models or the machine learning algorithms, which at their base could be considered an abstract idea, unless you really are coming up with a fundamentally transformative new machine learning algorithm that's completely unlike anything out there, then you probably would have a good argument that it would qualify for patent protection. So we're kind of advising a lot of clients, the distinction between trade secret protection and patent protection and whether one is more suited for AI innovation than the other. Often it's a hybrid approach where you want to patent certain elements of your AI system and then you want to keep the rest for trade secret protection. And we find that hybrid solution works the best for most of our clients, but it's really a case by case issue. There's a whole host of legal issues. You probably heard of the New York Times lawsuit. There's lots of potential copyright issues and class action lawsuits that have been filed. And we all know that AI is trained on a lot of immense amounts of data. So what happens if some of that data is copyrighted? So you've seen an uptick in litigation involving potential copyright infringement claims, brought against some of these large language models and other generative AI tools. Copyright law does have a fair use doctrine that would seem to apply, but the courts haven't yet definitively ruled on that issue. So that's a legal challenge, just how you isolate yourself from these potential copyright infringement claims. Data privacy is also another big concern with AI companies and the use of AI. I mean, these AI tools, they might be trained on your personal or sensitive data, and it might even output some of that personal or sensitive data. So that obviously it may raise privacy concerns. And then you have all sorts of potential liability issues when the AI system might make a mistake or others rely on its outputs. So you mentioned autonomous vehicles earlier. So there's a question. So if an a fully autonomous vehicle with no human interaction gets into an accident, then who's really at fault? Is it the liability is really not that clear? Is it it could be the vehicle manufacturer, it could be the developer of the AI system. If there was a driver that was actually in the driver's seat letting the AI system maneuver, then the driver could be at fault, or it could be some combination of actors under a joint and several liability theory. So our current legal liability frameworks, they're not particularly well suited to deal with AI. So companies using or developing AI really need to employ comprehensive risk mitigation strategies. And there's a whole host of other issues just developing those strategies. So it's an interesting time to be a lawyer, especially an IP lawyer, and it's an interesting time to be developing AI technologies. But there's going to be a whole host of legal hurdles that we envision that these companies are going to have to overcome.
Yeah, and again, you give so many great examples there, and thank you for that. One question I want to ask that's just popped into my head is, do you think AI is not going away? Technology is not going away. People can fight and contest it as much as they want, but that is the trend. You can fight it or you can get on board with it. Now, of course, there's lots of challenges along the way, but how is the legal system going to be fit for purpose? You've given great examples there where we still are behind the curve with technology going at that speed and the law going at that speed. What's the solution to your mind, or how do you get it to a level where actually there is going to be sustainable laws and regulation that can keep speed with innovative technologies?
That's another good question. I mean, I think the legal frameworks are going to have to adapt. You already have the AI Act in the EU, and you do have some legislative efforts to change some of these frameworks. For instance, like the liability issue that I mentioned to you. The liability frameworks really don't fit well with AI systems. You don't really want to apply strict liability, because if you apply strict liability shouldn't really apply anyway, because these systems aren't really inherently dangerous. And you don't really want to apply a strict liability framework to a burgeoning technology field like AI because it could stifle innovation. Companies, if they know, they wouldn't really develop a new AI system if they know they're going to be held strictly liable for any harms that come from that system. The fault-based models don't really fit either because typically, it's just you have to show a duty of care and then some, it so there's really no framework, either the fault-based models or the strict liability models that really fit AI systems particularly well. So I think the legal framework is just going to have to evolve and with the technology, and it's going to have to be kind of a coextensive evolution and constantly evolving as the technology evolves. And that's really the only way to solve the problem.
Yeah, again, something that comes to my mind I heard on a podcast not so long ago is kind of the concept of Amazon as a company. They're a continuous improvement company. They're always working on continuous improvement. The law is going to kind of have to be continuously keeping speed somehow, but in a way that is obviously, the rule of law and everything else that goes with it. So here's the question that everyone probably listening is still going to want me to ask you then, Brian. Is AI going to replace lawyers anytime soon? And you can caveat this response just in case it's 100% right or 100% wrong, but give us your...
I, I hope not. No, I mean, I don't think so. I think AI is going to be an invaluable tool that makes lawyers more productive and more efficient. The key is really to provide higher quality work product for our clients at a reduced cost. And I think that's what AI promises to bring. And that's what it's already helped. Our firm has already evaluated several AI tools, for example, discovery in a big litigation with millions of pages of documents. There already are AI tools that we are using to review some of these documents more efficiently and finding responsive documents, for example, more quickly, or finding potentially privileged documents to elevate those for a next level review. Because these big litigations are so document intensive, AI is just a natural tool that helps lawyers simplify the document review. And then with generative AI, some lawyers are using generative AI to help with legal research and even draft legal briefs. But you really have to have confidence in the output of those AI tools, and you really still need someone to double check that the analysis and the arguments, are accurate and sound and based in law. So, I think generative AI can save lawyers, countless hours researching case law and formulating arguments, but it's not going to completely eliminate the human element. And I don't think it really ever could. You'd have claims of the AI system, unauthorized, performing an unauthorized practice of law. Like there's really no human element there. So I don't see AI replacing lawyers. I think it's just going to make us more productive and more efficient, which is really a win for everybody, a win for the lawyers and a win for our clients.
Yeah, well said, well said. But it's not just clients that you advocate for in the courtroom and do a fantastic job. It's also you advocate for the LGBT community, which I know is important to yourself and also myself and our listeners here. So can you describe your work with the LGBT community? What initiatives have you been part of and what have been their impacts?
Sure. I've always had a very active pro bono docket, both at Ropes and Gray and at Quinn Emanuel. And the cases that I take on more regularly than others are asylum cases for LGBT asylum seekers. So I've done a handful of those cases, always had great outcomes. There's a lot of, we have relationships at the firm with other organizations like Immigration Equality that help refer some of these asylum cases to us. In addition to my pro bono docket, the firm also writes amicus briefs. There was one recently on Title VII of the Civil Rights Act in the Bostock versus Clayton County, Georgia case. And that was a case that Title VII, it prohibited employment discrimination because of sex. So the issue that the Supreme Court was facing was because of sex, did that necessarily prohibit discrimination of LGBT and transgendered employees? And the decision was it was a huge win, for the gay and transgender individuals who had challenged their terminations under Title VII. And the Supreme Court settled that legal question that had divided the lower courts about whether discrimination based on sexual orientation is a form of sex discrimination, which the Supreme Court found that it was. So fortunately, working at a big firm, there's just lots of opportunities like that for me to advocate for LGBT rights, and I hop on most of those opportunities whenever I can. But also through my pro bono docket would be the other main way that I'm a strong advocate for the community as well.
Yeah, no, and it's wonderful work that you're doing, and again, something we've talked a lot about on the show is diversity, equity, and inclusion, and obviously I know you're a big advocate for that in the workplace specifically. Can you talk about the benefits you see from diversity and inclusion in the legal workplace?
Sure. Yeah. I mean, I'm a firm believer that diversity of viewpoints leads to higher quality work products. I think it's just logical and makes sense. When everyone on your team is really thinking of the same solutions and no one's thinking outside the box, your work products and your clients ultimately suffer. So, I mean, diversity and inclusion, it really changes all that because you're bringing unique viewpoints from a variety of people with different backgrounds, different experiences to the table. Um, so in addition to higher quality work product, I think diversity and inclusion also fosters a more collaborative and collegial work environment. It also increases, I feel like it increases our attorney retention here at the firm. I mean, we do pretty well at recruiting and retention here, but I think because we have such an emphasis on diversity and inclusion here, we see less attrition than maybe some of our other peer firms. And I think at bottom, it really just increases employee satisfaction and it just promotes productivity. I mean, happy attorneys are productive attorneys. So creating an environment of diversity and inclusion, it even helps the firm's bottom line. And I mean, you probably know that Quinn Emanuel was like one of the first am law firms with a female named partner, Kathleen Sullivan. And we were also the first am law firm with an openly LGBT named partner, also Kathleen Sullivan. So the firm has been making strides in the diversity and inclusion arena for over a decade. That was, I think it was 2010 when Kathleen was became a named partner at the firm. So it's been over a decade that the firm has really been making strides in this arena, and we really see it as a key to the firm's success.
Yeah, no, and absolutely, and some great examples there that you've given. But I always say, whenever you're trying to create change, it's not straightforward, and there are challenges. And so, what are challenges associated with diversity and inclusion in the legal industry, and what can lawyers and firms be doing to ensure that they are creating a more inclusive environment for their employees and indeed colleagues?
It's another good question, Rob. I mean, it's no surprise that big law firms have traditionally been seen as boys clubs. I mean, it's really the large corporate law firms that have that stereotype more than others. But historically, I mean, general counsels of large companies, have been predominantly white straight males that like to interact with other white straight males, right? There's no surprise there. But now we kind of see the narrative changing. We have more and more minority GCs coming to the helm, and we're even seeing most of our requirements now for new work when we're invited to pitch a new matter. Part of the pitch actually requires us to list the diversity makeup of the potential trial team, for example. So we're seeing requirements from almost all of our clients, at least our big clients, to actually include the diversity makeup of the trial team in our pitches for new work. So I think it's key to our growth and key to our success. And I think the biggest challenge is really just overcoming those outdated stereotypes. And there's also one just around litigation in general. That litigation is also just for white straight men, and it couldn't be further from the truth. But I mean, fortunately, Quinn Emanuel is such a young firm. We don't really, we still have, you interviewed John Quinn on one of your earlier podcasts. He's, it's rare to have one of the largest litigation law firms in the world still have its named partner actively involved in the firm. So we don't really have a lot of those stereotypes that are deeply ingrained with other large law firms. But I think if we did, that would probably be the biggest challenge to overcome in the workplace. It's been pretty seamless here, but I mean, it's always an uphill battle just with recruiting and retention that we've talked about. We have a whole different channels of recruitment for LGBT attorneys, for example, and minority attorneys. And we're big supporters of those channels, and we've had great success with recruitment in those fields, but we could always do more and do better. So we're continually striving to do more and get more minority folks in the firm and keep them at the firm and promote them up through the ranks up to partnership.
Yeah, absolutely. Really well said. And we absolutely support that here from the show as well. But we've really only talked about your part-time job to date, Brian. So I'd like to talk about your other serious role as a father to 3 kids under 2 years old. So how do you manage to balance your, of course I jest, your personal life with, your legal career? What's the secret?
Oh yeah, man. Yeah, three kids under 2 years old, twin boys, and we have a 20-month-old daughter as well. Um, and we have a demanding dog as well, a Siberian Husky named Juno. So you can't forget. So we actually have 5 people in our family, including Juno. It is demanding. I wouldn't really recommend having 3 kids under 2 years old to anyone, but we were very fortunate to have twins in our second surrogacy journey. So and it's been amazing so far. There's never really, a lot of it had to do with timing. I didn't really know what the best at a big law firm, whether it was better to have kids when I was a junior associate, a mid-level associate, a senior associate, or just wait until I made partner. So I decided to go the latter route and wait until I made partner. So I was primarily focused. My job here at the firm, I think, was during the first 10 years of my existence here, it was primarily focused on just killing it here and killing it for my clients. And then once I made partner, I kind of reevaluated things and said, maybe now is a good time to do the family route. And I think it made a lot of sense. It made it with my schedule, it allowed me to kind of focus on the firm while I was an associate, and now focus a little bit more on family now that I'm a partner. But I mean, we have lots of associates with children, some with even more than 3 under 2. So you could definitely do it either way. I think the key, and I think we talked about this a little bit before, that the key is really having a place away from home and away from all the distractions to really focus on your work. And I really I just need some place to kind of separate family life from workplace and just kind of focus on each one. It's tough to try to seamlessly integrate the two because there's this competing, time pressures and other commitments. It just doesn't really work that well. Our firm, fortunately, has a work from anywhere policy. So, I mean, I could be on the ski slopes in Tahoe or by the pool in Palm Springs, and it all works out just fine. And we do a lot of traveling with the kids as well. Another key, I think, is just learning to delegate responsibility as much as possible. And we talked a little bit about that earlier too. So I try to really focus on just the most important strategic decisions and moving my cases forward. And that means kind of surrounding myself with highly competent, more junior attorneys that I can trust and rely on. And fortunately, here at the firm, we do have a lot of highly competent attorneys that I can trust and rely on. So it makes my life, a million times easier. So yeah, it's just tricks like that. And I'm still learning. I mean, the kids are under 2, so we'll see how it evolves. They always say terrible twos, so we'll see if that actually holds true with my kids, and see how demanding my personal life is. But so far it's been amazing, and we'll see.
We'll see indeed. Well, I wish you, well with that, I'm just listening and Juno, absolutely, I'm a parent as well as a parent. And I think they are absolutely part of the family. And, I've got a miniature dachshund called Otto. A lot of the community listen know, he very much is, as demanding as our terrible 2, although she's not so terrible. So hopefully it's not too bad. I think that's a little bit over exaggerated. So I'm sure you'll be absolutely fine. Brian, this has been a masterclass start to finish. I really enjoyed learning about your career, your journey. You've shared so much wisdom, and it's been a cutting edge conversation as well in terms of being at the sort of forefront of technology and the advice you're providing for your clients and all the work you're doing around the industry as well to improve it for good. If our listeners want to learn more, as I'm sure they will, about your career journey, or indeed Quinn Emanuel, where can they go to find out more? And is there any particular social media handles you'd like to share or shout out? And we'll make sure we also share them with this episode for you too.
Yeah, I mean, I'm on all the social media platforms, LinkedIn, Instagram. My handle is Captain Bem, so Captain BEM, my initials. And you can always shoot me an email at brianmack@quinnemanuel.com. I'd be happy to talk more. If there's any LGBT candidates, similar or technical candidates with similar backgrounds to mine, and they're considering whether they should move into the legal profession, I'm always happy to have that conversation.
Well, thank you so much, Brian. It's been an absolute pleasure having you on the Legally Speaking podcast. But now, from all of us on the show, wishing you lots of continued success. But over and out.
Thank you for listening to this week's episode. If you like the content here, why not check out our world-leading content and collaboration hub, the Legally Speaking Club, over on Discord. Go to our website, www.legallyspeakingpodcast.com, for the link to join our community there. Over and out.